You may have seen as it continues this wall-to-wall coverage of the audio of the Supreme Court hearing on presidential immunity. As you know, the ACLJ filed in this. We have argued 3 of these at the U.S. Supreme Court when President Trump was in office, but this question is a little different. This is about when you are outside of office, what would constitute an act that you could not be prosecuted for, and what would constitute an act that you did as president that you could potentially be prosecuted for after you served as president. And there were some interesting hypotheticals. What we argued at the ACLJ is, of course, there's never this full blanket immunity. It's not like the president can do whatever they want as president and claim that was an official act. We have criminal laws on the books that certainly apply. And one of the hypotheticals we'll get into later was, what if someone gave the president $1 million bribe to make them an ambassador? And my answer would be very simple. That is a crime. That is not an official act of the president because the crime came before the official act, and the crime outweighs the official act. So both the ambassador is compromised because looks like they didn't earn that position or didn't necessarily deserve that position. And at the same time, the $1 billion, if it really was considered a bribe. Now, you could get into some gray area there because a lot of major donors to campaigns do end up becoming ambassadors to some of the smaller countries. But I would say that's different than going to the president and giving him $1 billion. That's not a donation to a campaign before he is president of the United States. So there I'd say, no, that's not an official act, and thus you could be prosecuted for that once you were outside the presidency. And I think that most Americans would agree with that because you still then are, Logan, you're preserving what we need, which is presidential immunity for official acts, so that every drone strike that may have gone wrong but was still done in an official way with military telling you this is what we need to do, but it may have not gone perfect. We still need that kind of protection for presidents of the United States, whatever party they're part of. It is a major case, too, on presidential immunity. You don't get these often, and especially when you're talking about post-presidential immunity. I did want to point out something that's just unique in this case because there are 4 main charges against President Trump that have been brought by Jack Smith in the case. 2 of those charges, the Supreme Court heard arguments on last week to say that those charges were unconstitutional. And what that means is that at least 4 justices on the Supreme Court believed those charges were. It was brought by another January 6th defendant. So right now, during this oral argument, President Trump is being charged with a conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. Both, if the Fisher case throws out those obstruction charges, the conspiracy to obstruct an official proceeding and the obstruction of an attempt to obstruct an official proceeding, Jack Smith is only left with a conspiracy to defraud the U.S. and conspiracy against rights, which are much weaker to take to the U.S. Supreme Court, which they'll have to consider post-oral argument. I mean, this is why, Logan, this case can get very interesting and also take much longer than maybe predicted when it comes to this immunity question, and here's why. I think if you've listened to the oral argument, what you've seen is justices don't believe in blanket immunity for the most part, but they also don't believe in no immunity at all. And I think what they're going to ask is that lower courts come in, unless they want to make that decision on their own, that lower courts need to come in, and these charges against President Trump, whether it's the 4 that survive or the 2, because the other 2 do not, and the lower courts need to determine through a trial what is an official act, okay? And then what's an official act that could be combined with a criminal act that would then negate its ability for the president to use that as a defense. So that'd be one. And the second, of course, would be is what are unofficial acts while you are president of the United States that could be criminal that you can then be prosecuted for after you're in office. So you see there, again, you've got to kind of splice this down to, and I think that ambassador question, it got right to it. Do we have the sound from that so we can play? Because I think this was the key. It was combining a very official act of a president, appointing an ambassador, with something that we all know is a serious crime, bribery. Take a listen.
Well, what if you have, let's say, The official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay,
subsequent appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
So, I mean, there again, I think in simple terms, what he was saying there, that President Trump's attorney, just clearly, was that when you've got something that looks official, but that a very much criminal act came with it, and this would have to be bribery. It cannot be someone donated a lot to a campaign, 6 months ago and suddenly became ambassador to Antigua. That is not what we're talking about here. We're talking about you coming in and saying, here's $1 billion, or I'll wire you $1 billion into your account if you make me an ambassador somewhere after. This is when you are president of the United States, because that's what we're talking about in this case. When can you be prosecuted for acts as president when you're no longer president, not acts you may have done before you were president. So again, just to kind of clarify that for people, I think that's where the Supreme Court would be on this fine line. And if you go to aclj.org and you want to learn about this, we've got our brief there. We filed that amicus brief, and you'll follow exactly what I'm saying here is basically our argument within that brief. But Logan, let's get to the phones.
Yep, let's go to Todd in the state of Georgia. Todd, you're on the air.
Hey, Todd.
Hey, thanks for taking my call. How would you compare and contrast the justice's hypothetical with the video of Joe Biden bragging to the Council on Foreign Relations about withholding foreign aid in order to get a prosecutor fired that was investigating his son?
Yeah, I mean, listen, I think that one was borderline. I mean, remember, there were certainly investigations into that. Now, he was vice president, so that changes things a bit. It was also whether or not he had authorization to make that kind of threat, because providing U.S. aid to countries can come with strings attached, Logan. It didn't sound great. The reason it didn't sound great is because there was a dispute over whether or not that prosecutor was looking into Burisma, which his son was on the board of. So while it sounded like it was a kind of like a tit for tat moment, you certainly, as I would not want to put the president or vice president in a position in the future, Logan, where they can't say to a country, if we're going to provide you with this $1 billion, right, that you don't need to make this A, B, and C change before you receive it. Now, Joe Biden did it kind of a tough talking way, like a mini Trump kind of sounding way, but in a way that I think the real controversy there was, were you trying to fire the prosecutor because he was looking into a company your son was on the board of?
Some of it's different when we've had situations like the hostage releases like that, where sure, you want to have to be able to play with what you got. And sometimes you have to be able to have these important negotiations and conversations. And whether, like you said, whether they sound like they're on the up or not, sometimes they are in the best interest of the country.